Well, good morning, everyone, and welcome to a new ForoCompetencia breakfast. We have the honor today of having with us Ian Forrester, who, currently is an ordinary member of the Competition Appeals Tribunal in the UK, but formerly he was a judge at the General Court of the European Union in Luxembourg. So he will be speaking to us precisely about the judicial review process of competition cases in the EU. So, Ian, the floor is yours.
Very good. Well, it's a pleasure to be talking to an old friend. I'm sorry about the background noises. And to see on the list a number of old friends to talk about the familiar subject of competition law and how it has evolved and how it has been examined by courts. Now, I have had the special experience of starting off as a litigator, then being a judge in Luxembourg, and now being in private practice once more, still somewhat in mourning for Brexit. So what I want to talk about is to introduce a little bit of history, which I think will make the European experience easier to understand. And in addition, I think that the European experience may well be parallel to experience in other countries in Latin America. So let's start at the beginning. In the 1950s, the Treaty of Rome was drafted in Brussels by people who had, among the other things, the principle of drafting a set of what the Americans called antitrust rules. And they didn't really know quite what they were doing. They were babes in the woods, would be the English expression. So they had somewhat strange goals. One of them wanted religious discrimination to be caught by the competition rules. And so if you look at the drafting notes that went back and forth between them for what became 85 and 86 and following of the Treaty of Rome, now 101 and 102 and following, you'll see there was a lot of confusion about what were the goals. But finally, a text emerged and it was accepted, and indeed that text has been echoed, not quite duplicated, in more than 100 countries around the world. So the notion of prohibiting bad cartels, bad understandings between enterprises, and obliging dominant players to play to a slightly different special set of rules, that concept was elaborated by the drafters of the treaty back in the mid-50s, and it became enforceable via a regulation adopted in 1962. And from about 1970 onwards, the European Union had a set of competition rules which they were able to apply. Now, in the early days, there was no confidence on the part of the European Commission that the rules would be sympathetically examined by businesses or indeed by national courts. And so their first approach to the competition rules was rather defensive, very cautious. Almost everything that was big was liable to contain a restriction of competition. And restrictions of competition, even if they were on balance desirable, needed to be blessed by the European Commission. But the European Commission didn't have enough resources to give all the blessings that were necessary. And so there was a degree of artificiality, even absurdity in how the competition rules functioned from about 1960 to say 1990, 1995. There were some changes which were very important. First, there was the discovery that it was possible for the European Commission to take in merger cases decisions which were clear, short, and above all, rapid. And that was the great difficulty, the weakness of enforcement up till then. The idea was perfection. Each decision was really a piece of new rulemaking as opposed to a, a determination of the rights or wrongs of a particular problem. And a perfectionist administration tended to go very slowly. Now, there were appeals, of course, to the decisions which were taken. Generally speaking, the Commission was successful in the great majority of the cases which went to the European Court in Luxembourg. First of all, the Court of Justice, and then after its creation, the Court of First Instance, now called the General Court. The experience of litigators like myself practicing before the Luxembourg courts was that it was pretty difficult to win against the European Commission's taking of a big competition decision. It did happen, and sometimes, especially after the creation of the new court, the Court of First Instance, the Commission generally procedural questions were occasionally very severely dealt with. But there was a sense of not a sense of imperfection with respect to some of the judicial output in the 80s and 90s. Then, in 2004, European competition law was revolutionized, if that's the word, by the removal of the Commission's monopoly on the granting of exemptions, particular blessings, and by the arrival of 10 new member states and the granting to national courts of the possibility of applying fully Articles 101, 102, as opposed to considering whether there was something caught and whether an exemption had been adequately granted. So competition law became, my word is, nationalized from 2004 onwards. And whereas before that time, the incidence of private litigations, that's to say, ordinary people suing enterprises or the other way around, using competition law as the basis of their claims, those claims had been not unknown, but quite limited. And the cost and difficulty of bringing claims, for example, by victims of cartels, would clearly had the effect of making it unlikely that, for example, a parent who had been overcharged for 3 football shirts purchased for the children, and the football shirts were cartelized, the parent might have lost £100, but £100 would never cover the cost of seeking compensation. So the shift that has been observable for the past 20 odd years is that access to litigation has been encouraged by a number of developments. One, the damages directive, which took a long time to emerge and was much debated, but which is definitely being used regularly by people who feel that they have suffered due to a breach of the competition rules. Now, in addition to the damages directive, we can observe national actions where it is indeed routine to make competition law arguments. In addition, we can observe, and this is very relevant to the damages directive, the emergence of funding for litigation. Now, when I started at the bar, it was unimaginable that a private company would advance cash to a firm of lawyers in the hope that they would turn that cash into big awards of damages. And the extent of those funds is truly astonishing. In the case of, in a recent case before the Competition Appeals Tribunal, the sums proposed, and this is public knowledge, were £35 million. So huge damage, huge sums of money are available in London, Amsterdam, other cities to fund the bringing of litigation. So there are more cases arising, and there are more incentives. Incentives is maybe the wrong word. There are a number of factors favoring the emergence of regular litigation on competition matters. So that brings me to the question of how judges do and should approach the examination of a competition problem. Again, a little bit of history. It's very understandable in every jurisdiction around the world, I would guess, that the public authority who has taken a decision says to the judge before whom a challenge is being heard, we're the experts. We really looked at this very carefully. We know about this stuff, and we realize the impact that our decision would make. But we're not stupid, we're not crazy, we're not hasty. We look at the evidence, and although the company feels angry and says its rights have been infringed, we listen very carefully to every argument that was made, and they're wrong. Now, when a public authority hears that, well, maybe they're right. And this notion of administrative law, that's to say, illegality rather than merits, is a topic which is very properly difficult, sensitive, and by no means easy to predict. Why is that? Well, if we imagine, first of all, a quite simple matter, well, maybe not so simple. Imagine in a local authority, the disabled people are entitled to free travel on public transport sometimes. Now, supposing the public authority says that person, yes, there is an injury, there has been an injury, yes, there's a problem in walking, but it's not serious enough to meet our criteria, and no, the girl does not get a free bus pass. The official who has honestly tried to find a good answer and has decided, no, she doesn't qualify, is not accused of corruption, is really accused only of making a decision which was mistaken. Now, should the court interfere in those matters? And to what extent should the court defer to the conclusion of the person on the ground in the front line? And that has been something that I absolutely insufficiently recognized in my early days as a litigator. That's to say, I argued merits all the time, and the courts listened to me, but actually, I should have been stressing more the illegality, the breaches of procedural principles which justified the court taking a decision that the public authority, the European Commission, had got it wrong. So the question of how much expertise we should attribute to the public authority and how much leeway we should extend to them is a very sensitive and real question. Sidestep a moment. In the case of Halcor, which I was involved in before the European courts, and in the case of Menarini before the Strasbourg court, in both these cases, the two courts reminded us, I think correctly and wholesomely, that the taking of a competition decision presupposed a thorough examination of fact and law relevant to the case. In other words, it was not the case that judicial review should be limited. Judicial review, especially in a quasi-criminal matter like competition law, must involve a proper examination of the facts and the law, not merely whether the public authority had the right to take the decision. Now, let me offer an example. Supposing it's a case concerning cars, and the question is whether the question relates to electric cars or hybrid cars. And if the public authority says hybrid cars and electric cars fall in the same market, then the electric manufacturer is not dominant. Let's suppose that. And correspondingly, if it's separate markets, then there would be dominance. So it's that normative choice which the public authority says it's entitled to make. Now, should the courts be willing to intervene and disagree and say, no, you got that wrong? I think they should be ready to intervene when there is clear evidence that the decision was irrational. It looks strange. It looks crazy. That is a very odd result. So, in those circumstances, the entry of the judge into the examination of the case and the readiness of the judge to say, I, I disagree, not because I think you came to the wrong conclusion. In other words, not merely because of merits, I'd have come to a different conclusion, but because of the wrong approach to the case. Now, this is a quite delicate and quite controversial problem. It's controversial in the sense that the the procedures by which competition decisions are made can be criticized, and I and others have criticized, commented on how decisions are made by the European Commission. Now, that leads me to the next subject, which is that of administrative procedure, the procedure by which the authority reaches the conclusion that there has been a breach of the rules. Now, the there is a there are tensions, there are problems, there are phenomena which pull in different directions. On the one hand, the European Commission and others, but let's stick with the European Commission, they want not to be criticized for omitting important points. Yes, the question of da 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 da, it's only a small question, but if we don't address it, maybe we'll be criticized before the court. So the Commission includes in its decisions every small thing which has been the subject of discussion, even if it isn't really a terribly important point. And they give footnotes. And the consequence of that approach is that the underlying decision, the competition law decision, can get extraordinarily long. You may find 500 pages, 700 paragraphs. The difficulty with that, there's a number of difficulties. One is that it's okay for the individuals who actually have been involved in the case. They can navigate their way around and they can know what actually what were the core questions at stake. But the the essential points, the big controversies, the issues of principle, those may be hidden, invisible, or more accurate, drowning in the 500 pages. Putting it more simply, shorter decisions expose the authority to the criticism of being incomplete, but long decisions expose the authority to being obscure by the sheer length of its decisions, which make it almost unjusticiable. So, one suggestion which Advocate General Niels Wahl suggested a number of years ago, and which I think deserves consideration, is the idea of pruning, clipping, reducing the number of big questions to a smaller compass. That's to say, by having certain questions of fact or law clarified by something like an administrative law judge in Brussels. Now, the advantage of that would be shorter opinions and discarding peripheral, smaller matters. The disadvantage is it makes things slower and more complicated procedurally. So that question still remains. Now, I've served in the court in Luxembourg, and also as a member of the CAT in London, and it's a wonderful, fascinating experience. The Luxembourg one is particularly rich because of the great variation of personalities, of legal backgrounds, of language, of legal culture. And so I sat with Lithuania, Austria, Italy, Cyprus, Spain, Netherlands, all these extremely interesting, very highly talented people, but with an extraordinary range of professional experiences. So some had been diplomats, Some taught law, some were civil servants. The range was very great, and a few had been legal practitioners. So the and a few were working at the European Court in an administrative capacity, not as judges. So the richness of the personnel on the court meant that there was perhaps a contrast between the common law judges from Ireland and the UK and to a degree Malta and Cyprus and the civil law traditions of the other judges. For example, how intensely to question counsel, whether to have an open debate during an argument, and or whether to refrain from putting too many questions for fear that the judge might come across as partial, as having made up his or her mind. So that richness was the most extraordinary feature of the work of the court, and I enjoyed very, very much that diversity. Now, at the same time, there is a reluctance on the part of the court to encroach on the choices made in enforcement matters by the European Commission. That's absolutely proper and cannot possibly be criticized. But it is nonetheless a difficult factor for judges and for counsel appearing before them to decide how intrusive the judicial review that's required by the Halcor case and the Menorini case, how intrusive, how skeptical should the appeal be? Should it, as in some older cases, involve quite a high degree of deference? There was an evidentiary basis for the decision. It's within the powers of the authority. There was no corruption, and it's evident that there's disagreement as to whether they took the right course of action, but there isn't an illegal, there was not a breach of the principles of legality. Or on the other hand, this is crazy. All they did was add a new feature to their software, and that was a good thing. So those tensions, those debates are real, and it's important to be aware of them when you're going to make submissions in Luxembourg. That's yes. One, this question of what I call over judicialization. In India, about, I think, 20 years ago, maybe, the competition rules were so easily challenged by way of appeal against enforcement that enforcement efforts were almost paralyzed. And that's undesirable. And so we have to get right the balance between access to a court in due time to challenge the measures being considered or being taken and not slowing down the process to an absurd degree. Because you can be sure that every time the authority, the antitrust authority, is tempted to say, yes, we're going to go ahead, they will have received kilos of paper, electronic and real, giving examples, and for yes. And they will also have received piles of documents making the argument for no. So a choice has to be made about how far it's appropriate to criticize the European Commission, for example, for making what I called earlier was a normative choice. If the judicial review is too intense, then it may have the effect of second guessing to an unreasonable degree the choices made by the enforcers. And very last point, I, in support of my proposition that decisions, at least out of Brussels, are too long, I invite a diligent PhD student looking for a thesis to compare the output, the judicial output of the General Court in Luxembourg and the Court of Justice on matters of competition. And I think that the Court of Justice answering references from national courts has got a successful knack of framing the issues of principle and then discussing them in a manner which the the General Court lacks the advantage of having a well-focused question put to it. And so I would like to see shorter, crisper decisions coming out of Brussels in the next while. But sitting and listening to argument about competition law disputes has been a fascinating part of my life. And it's nice to share these thoughts with friends in Latin America.
Great, thanks, Ian. Very interesting. We now open the floor to questions. While the others think of raise their hand, I have one question. You have been in both sides of the bench. What would have two things? What did you find when you became a judge that you didn't perceive from outside the court, and therefore the second question would be, what would have you done differently if you were back in the litigator's side?
Well, I guess what was a surprise when I arrived in Luxembourg? Well, I knew that the working language of the court was French, but I didn't know how pervasive was the relevance of that fact. In other words, the deliberations were conducted in French, and the notes after the deliberations, where the judge would say, I'm happy with the bottom line, but paragraph 98 goes too far. I would like this paragraph to be included. Now, that was done in all of that would be done in French, and although my French was pretty good, it was important to get the grammar perfect. So the linguistic aspect of being being a judge was something I had rather underestimated. It has advantages. It means that there's always a French original and there may be errors of translation, can happen, but the original text will always be the one that was drafted in French by the juge rapporteur. That was one thing. A separate one was the big disparity in approach by judges of different nationalities. It was obviously a natural, I wasn't surprised, but it was intriguing to observe it. For example, how far should is it proper for a judge to go in putting questions to counsel? So, in the French tradition, the judge might say, on page 14, you say 1.47, but then on page 19, you seem to be saying 3.9. Can you explain? That's a question. But the English or Scottish or Irish judge says, Mr. Pena, you make this argument on page 7. How can you possibly say that's correct? And then there ensues an argument between the judge and the lawyer. Now, the judge is not saying, I'm going to find against you. He is just testing by hypothesis uh, whether he agrees, whether there's a good response. So that was another question, another subtlety of life in Luxembourg. And then in competition matters, I didn't do that many, but I did find that it's difficult to get your hands around 500 pages. They're drafted quite quickly in order for the deadline of 2 months, 70 days to be satisfied. And looking for the issues of principle is may be difficult, or maybe it may be easier and not inappropriate to focus instead on the procedural matters, whether someone was given enough time, whether certain documents were properly shared, access to the file, and so on, because those are topics which the judges are more familiar with. And then the last thing I would have to say about the experience of being a judge in Luxembourg, it's very, very friendly. The collegiality of colleagues is admirable. And so it was a small 2,000 people, not that small, but it was a community engaged in seeing European law develop and being applied. Extraordinarily rich and interesting environment. And what would I have done differently as a litigator? I would have focused less on they got it wrong and more on how they erred in their analysis and got it wrong as a result.
Okay. I have a follow-up question. If no one raises their hand, is you mentioned the importance of French and how relevant do you think that knowledge of economics have played in the analysis of the judges?
The judges have referendaires, law clerks, I suppose is the English translation, and they are good at French. as a requirement, obviously, of working in the court. It sometimes happens that there are requests to speak English. So a judge might say in the deliberation in private, désolé, je ne peux pas m'exprimer d'une façon parfaite en français, puis-je parler l'anglais? And then the judge explains in English the subtle point that the judge is trying to make. So those linguistic matters, at the beginning of my time in Luxembourg, I thought that it would be very useful for English and French to be alternatives, as is the case in Strasbourg. But I learned from experience of how complex the process of producing decisions in 24 languages, including Irish, Lithuanian, Maltese. Those challenges are enormous, and the idea may come of having English as an alternative working language, but it's far more procedurally complicated than I had ever understood at the beginning.
Thanks. Paulo?
Yes, hello, Julian. Can you hear me?
Yes, perfectly.
Yeah,
Sorry.
hello, Ian. Hello, everyone. Nice to see you. I was just wondering, you mentioned that, it's just a curiosity, you mentioned that the atmosphere, the environment was quite friendly between judges in Luxembourg. I was wondering if you can expand or at least how come, how was that able? And I explain where I'm coming from. In Latin America, I have the feeling that usually judges will try to divide in subgroups in order to make their point, their position, their theory of overrule their colleague or subgroup. Do you think that the friendly environment is more due to the substance because it was sort of the European law being built, or is it more a cultural aspect because people are more civilized? What would be your reaction to that?
Maybe it's the food in Luxembourg that makes people peaceful. Um, Well, I guess I'm not sure, but I could offer a few possible explanations. The judges come from 28, used to be now 27 countries. And to be chosen is a big honor. And the job is properly regarded as something very special. So I think you have respect for the person with whom you disagree. So my experience was that we used to have the great majority of cases, the great majority, yes, yes, in a majority of cases, reaching a conclusion was not difficult. We were all three or all five or all 15 were would go in the one direction. It did happen that there were occasions where people disagreed. And my experience is that the battle, the dispute, the debate in the délibéré, which is the name for the concept of sitting around a table in deliberation, that concept was most, what shall I say, um, the battles could be really robust. And at the end, no consensus, so we're going to have another deliberate, and maybe another one, and maybe another one. And I've had the cases happen where there's more than 10 attempts to reach a consensus. But I don't think that people afterwards were grumpy towards each other, were hostile because they had not had their way. I maybe I was too innocent, but my experience was that the process of reaching a decision in a important case involved good humored argument, lots of notes back and forth in rather old-fashioned French, and then finally a conclusion. Yeah, people got heated, but I don't. My experience was there wasn't much plotting. Now in Latin America, maybe Spanish American food makes for greater passions.
Thank you. That's very useful. Yeah, maybe the weather or the temperature.
Yes, yes, exactly. And the red chilies.
Esteban.
Thank you. Hi, Ian. Thank you for your comments and thoughts. Maybe two questions. One is referring to how do you compare your experience in Brussels with European competition law judicial review with UK competition law judicial review after Brexit? And the other is if you think it could be some problem or gray area in judicial review in digital markets with all the new regulations that maybe create some areas where it is not clear if which kind of law or regulation will apply.
Well, on the first, my experience with the cat has been limited. I was appointed quite recently, so I wouldn't speak generally about the cat. One observation is that it is a very well-funded, well-organized, beautifully equipped court. That's to say in London. And in a big competition case, there may be many, many expert lawyers. And litigation funding makes that possible. So the quality of the debate and the thoroughness of the decisions in appeals, those are very impressive. There's also the British tradition of oral debate. So during the argument, the judges put questions, and the oral argument, my usual analogy is to show like this. Here's the decision which has to be taken. Here's the start of the case, and there's the final judgment. In the UK tradition, the oral portion is a big piece, and oral debate is part of the route by which British judges reach their conclusion. By contrast, in the General Court, the judges have, sorry, I'm trying to make a gesture and it's not really very useful. by contrast, in the general court, the judges have internally debated between themselves the way to go. And so before the oral argument, each of the judges will have a well settled preliminary opinion as to which way to go. And the oral bit comes closer to the end of the judicial process, and it's and therefore it is less important intellectually than the British approach, where the oral bit is a major part of the process of decision making. And then you ask a very good question about how will judicial review work in the so many other areas which are potentially controversial. And there's the right to petition the public authority, there's financial regulations, there's health and safety, where and whether and how far should we trust the technical expert? I don't know where the institution, I don't know how the institution is going to develop a rule book for examining whether 0.98% of a chemical is too much or too little. The expert says, oh, it's far too much. The man from Sweden, the Swedish government says much too much. And the official from Spain says too little. Now, how to reconcile those cases? I was involved in a few debates about the precautionary principle when I was at the bar before going on the court. And I still feel that it would be sometimes helpful for judicial review to be quite skeptical about the invocation of the precautionary principle. But I don't have enough experience to give a more confident answer.
I have a follow-up question to that, and perhaps we can get a similar answer, but the Draghi report calls for competitiveness elements in the analysis of competition cases as well. So how open do you see the possibility of that resisting judicial review if the European Commission starts introducing these kind of elements in the decision making?
Elements of
competitiveness.
I see. I think that's I apologize for saying it so often. That's a very good question. Because it goes to the question of deference, and to what extent should the judge say they're the expert, they make the policy, and if the policy isn't illegal, if there's no corruption, if there's no obvious failure to examine the evidence, then it's not for us to disagree. It's not for us to second guess the public authority. Now, that's easy to say, but in some cases, the matters at stake are so hugely important that it may be unfortunate or a pity no, not a pity. It may be that the judges relying on Minorini and Halkar feel that they have to apply judicial reasoning to examine the adequacy of the justification for taking the measure. Yes, it says it'll help competitivity, but we're still not satisfied that the grounds are convincingly set forth. Something like that. I don't know where that's going to end, and I'm afraid that the polarization of political dialogue in the United States, but not only in the United States, may make the issues even worse, even more difficult.
I have what is the level of communication between the of cooperation between the judges in the European level and the judges in the national level on competition issues? Is there a network of cooperation, or there is that has been developed, or there is no dialogue among judges?
Well, I can give a clear answer to that question. The court invites, that's to say, the court in Luxembourg invites the magistrat of each member state to come to to Luxembourg, for a review of pending problems. And there's also, and on that occasion, it's interesting, all the translation booths are occupied, and there are real debates about how European law is functioning. And then there's a dinner, and there's a lunch, and there's the opportunity for discussion in Luxembourg with a certain focus on the European side. In addition, separately, there is FIDE, which is the meeting every 2 years of academics, practitioners, civil servants, and judges in a different country. And that's a vehicle for discussing common problems, major developments, and so on. And then also there's the Association of European Competition Law Judges, which meets twice a year, and I think more. I'm not going to say how many meetings it organizes, but there's a lot of preparation for the meetings when they occur. And there was one 2 months ago in Portugal, and there something like more than 100 national judges and European ones came together to discuss common problems, to hear about national important judgments, and to talk about, for example, litigation funding and privacy. Yeah, so to answer your question, there are regular meetings about competition law, and those meetings occur several times a year, usually under a variety of formats. You were in Edinburgh earlier this year for the meeting of the ICN, and that was a great occasion, which I certainly enjoyed. And it's an opportunity for talking about controversial cases, big policy choices, and to inform about how my jurisdiction has approached the problem of commercial secrecy for a business process, which, so the short answer to your question, yes, there are regular and quite frequent consultations between competition law judges.
Thanks. Giovanni.
Yes, thank you, and thank you very much for your presentation. I work on intellectual property and competition policy issues here in Geneva at the World Intellectual Property Organization.
Oh.
And my question is this: what I seem to have witnessed over the past few years is an expansion of the scope of competition law and enforcement to take into account or to assess aspects in companies' conducts that are not, let's say, part of the traditional area. And what I mean, for instance, environmental concerns, should, competition authorities take into account the impact on the environment of certain agreements between companies, or the impact of certain conducts also on the job market. And of course, also in my area, intellectual property, how should competition law take into account the aspects of certain conducts that are related to intellectual property? Now, so my question is, do you see this expansion somehow in the scope of competition enforcement as a positive development, or, competition enforcers should kind of stick to their old traditional areas of responsibility? Thank you.
That's an easy one. I remember in the early days when I started practicing in Brussels, there was an obsession about parallel trade, and the Commission didn't have great powers, didn't have great support enthusiasm among the member states, and I suspect was regarded as rather a hostile entity, a nuisance. Now, at the end of about 20 years, I suppose, 25 years, obstacles to parallel trade no longer represented a big part of the Commission's concerns, or of the cases brought to the Commission. They were easy to bring, of course. And then there crept into some decisions references to the environment, to green causes, and such like topics. And the spread of matters of concern certainly has continued. And I would say that competition law is now, at least in some sectors, approaching or moving away from being the punishment of infringements to regulation and organization of the marketplace. And I'm thinking of the DMA. It's not a bad thing, but it is a different thing. And I suppose that I would reply to your interesting question by saying that it's inevitable that the justification for big competition law decisions can sometimes include matters which are not at all traditional from the point of view of competition law. Like, as you said, environmental matters. Now, would we see a company fined under Article 101 because it or Regulation 17 or Regulation 1 of 2004, would a company be penalized for not respecting environmental norms? I kind of think not. But I could imagine that there would be controversies about whether environmental norms, respect for IP rights, and so on, had been infringed or had been respected. So there was litigation some years back called Grüne Punkt, where the idea of a label which was pro-environment, under what conditions could that be applied? So I don't think we'll get away from, I don't think it's realistic to say competition law ought not to take account of environment, migration, social considerations, because that's part of life, and competition law is being used in creative ways. I don't think we can stop it.
Elodie?
Yeah, hi. I'm very sorry I cannot turn on my camera. I have a problem with it. I just have a quick follow-up question on this one. As competition law is expanding, do you think that, like to other, as you said, other concern, would you think that new or other remedies should be put in place as well, aside from fining companies, for example?
Oh, well, I would say in cartels, I think it would be wholesome, desirable, useful for company employees to be the ones who are the targets. Cartels are extremely rare in the United States, and there's a number of people in jail. Usually, a high percentage of them are foreign for breaches of the competition rules. Now, instead of imposing, or as well as imposing fines upon the corporations in enormous amounts, I would have thought that 6 months in jail would be a very effective deterrent and encouragement to people to avoid infringing conduct in the future. So that would be one change. There are today, in a few member states, the possibility of criminal charges, but the experience has been really quite limited. I think that there would be a much more inhibitory effect if people who had engaged in a willful cartel activity were at risk of being accused criminally and tried criminally.
Perfect. Thanks. I think we're running out of time. So, Ian, please, your concluding remarks.
Concluding remarks. Oof. Well, I feel enormously privileged to have been for more than 50 years engaged in the competition law field. I've met intriguing people, fascinating people. I've had threats, and I've had praise and criticism, and lovely colleagues. I have no intention of retiring from the field because it's fun and it's interesting. And I do like the idea that people in people around the world can participate in discussions like this, because it's a discipline which is important, and the technological opportunities which we have available are such that it's possible for me, sitting in Edinburgh in Scotland, to be talking to someone in Argentina and someone in Geneva and others around the world about common experiences. And we don't agree, and we don't ask perfect questions, and the speakers don't speak with perfect clarity. But little by little, we better understand what we're doing. And competition law is intended to encourage commercial fair play, decency, opportunities, the opening of markets. And as long as it does that, I shall be proud to be a practitioner. And I welcome this breakfast initiative, because it allows people of different backgrounds in different countries with different native languages to talk to each other and argue and agree and disagree, think for the future, and then go on to work a useful day. I think that's great. And I thank you for inviting me.
Yeah, thank you very much. It was a privilege, and your experience was. Thanks for being so generous in with us with regard to your experience in Luxembourg, which is fascinating indeed. So the next breakfast will be on September 28th, and the guest speaker will be Cristina Cafara, and she suggested an interesting topic. She said, antitrust and regulation in a decline spiral. Why it's our fault, and what can anyone do about it? So that will be in September 28th, and I look forward to seeing you then. Great. Thank you very much.
Very good. Thank you. Bye-bye.
Great to see